Hello everyone, I am Bikramjit Singh. I'm Canadian immigration lawyer from B.Kay Law Office, which is located in Edmonton, Alberta, Canada. Today I'm going to talk about the most important and rarely discussed topic regarding temporary resident visa applications, which are work permit applications, study permit applications, and visitor visa applications. And the topic is dual intent. Intent means intention and dual means two. It means when you have two intentions. But what does it mean under Canadian immigration laws? Under Canadian immigration laws, it means that when you have intention to stay in the country as a permanent resident, and you also have an intention to stay in the country as a temporary resident. And when does this dual intent happens? It happens when you have an application for permanent residence in processing with the Immigration, Refugees and Citizenship Canada, IRCC, and you also submit your application for visitor visa, study permit, or work permit. So when you have both types of application in processing are going to be processed by the immigration office, in this case, you have to prove to the immigration officer who's working on your file that you will leave Canada by the end of your authorized stay in the country as a temporary resident, irrespective of the final decision of your application for permanent residence. It happens most of the time when, for example, if you have applied for permanent residence under spousal sponsorship, or you have applied for permanent residence under any immigration program, but you also want to visit the country as a visitor to stay with your family member, to stay with your spouse temporarily for the time being during the processing of your application for permanent residence. In such situations, you have to provide as many documentation and as much information as you can to convince the immigration officer that you will comply with the conditions of your temporary resident visa or temporary resident permit, irrespective of the decision of your permanent resident application. So, for example, if you're coming as a visitor, what is the purpose of your visit? You have to explain that in very detail. For example, if you're visiting your spouse, you have to explain that why it is important to visit your spouse at this time. For example, if your marriage anniversary is coming up, you will provide proof of your marriage anniversary, and if you have booked any venue for that, you have to provide proof for that. If you are visiting your spouse or visiting any family member to attend their birthday celebration, you have to provide proof for their birthday celebration, their birth certificate that there is a venue already booked and where you will be attending the birthday celebration and how long you will be staying in the country. If you're coming as a worker, you have to provide proof that why it is important for you to come to Canada as a worker. Is your job is going to be very helpful to the Canadian labor market, and why your employer is need you urgently. Can they wait for your application for permanent residence to be processed and then you can start your job? If you're coming to Canada as a student, you have to explain that why it is important for you to come to Canada as a student at this time, why you cannot wait for your application for permanent residence to be processed first and then come to Canada as a permanent resident and then study. The second thing, you have to provide documentation and enough information regarding your duration of stay in the country, that how long you will be staying in the country. It depends on the purpose of your visit, that what purpose you are visiting for, and how long it requires usually if someone is visiting for such purpose like you. In addition to that, you have to provide sufficient documentation to prove that you have sufficient funds. For example, you have bank balance, or if someone is going to sponsor your visit or sponsor your study, you have to provide documentation who's going to sponsor your study or sponsor your visit and where that money is coming from, how that person is related to you, and do you have sufficient funds, or does the person who's going to sponsor you, they have sufficient funds to pay your return ticket to your country where you are coming from. In addition to that, you have to convince the immigration officer that if you have ever traveled in the past, you complied with the conditions of the visitor visa or temporary resident visa of that country. And if you don't have any travel history, then make sure explain it to the immigration officer that why you never traveled in the past and why you are only traveling to Canada as your first country of visit in your life. So make sure that you provide sufficient documentation and sufficient information to the immigration officer to do the proper assessment of your application. Dual intent is 100% legitimate under immigration laws. If the immigration officer still denies your application, provided you provided all the documentation and information to the immigration officer, if the immigration officer still denies your application on the basis of one and the only thing, and that is because you have application for permanent residence in Canada, then you can challenge the decision of the immigration officer in the federal court through the judicial review application. But it is very important before you go ahead with the challenging of the decision that you provided all the documentation and all the information to the immigration officer. Because if you were at fault, you didn't provide all the information and documentation for the proper assessment of your application, then it becomes very difficult to challenge the decision of the immigration officer. If you have any questions regarding dual intent and if you are in such situation, feel free to contact my office at 780-729-0007. This is also our WhatsApp number, 1-780-729-0007. Thank you so much. Have a nice day. Bye.